So you got to mute. Sorry. So James Robertson, and then I also have Isabel Rogers are two law students that are interning with me this summer. And so they're going to be observing. They're actually in my office listening, but they're also logged into Zoom so they can see you guys. Um, so I have you guys down for a dispute regarding forming and shoring solutions versus Stone Mountain access systems. Specifically, I have my understanding is that the issue is a notice of deposition that was served by plaintiff for the deposition, the 30B6 deposition of the defendant. And there was a dispute about the allegedly overly broad nature of the areas of inquiry that were identified in that 30B6 notice. Now, I did see that an amended 30B6 notice was filed that seems to have, tried to limit the universe. But one of you, I assume, I don't know which one of you represents which party, but the counsel for the defendant filed a motion for protective order alleging that the areas of inquiry were overly broad, et cetera, seeking to be protected. And that's actually the motion that's on for discussion today. As just a reminder, I understand why y'all need to file motions because you need to, perfect your record in the event that it becomes an issue. But actually, my standing case management order says don't file a discovery motion until you call the court and say, hey, we have a discovery dispute. Can you help us resolve it? So that's what the purpose of the hearing today is. My first question, though, is have y'all by chance resolved this already and don't need anything from me today? Mr. McCarthy, tell me who you represent.
Your Honor, Brendan McCarthy, represent forming and shoring. Your Honor, we have taken depositions of some of the individuals, which again can address some of these. I'm not a guy who spends a lot of time on discovery fights. I've been doing this 35 years. Nobody ever wins those, and the clients get billed a lot of money for them. Your Honor, I'll let Mr. Adams go forward. It's his motion. We're just trying to find out what they're going to testify to at trial and be able to head that off if there's something that they're going to testify to. And if they're not going to testify to something, then just stipulate that. I mean, that takes care of a lot of the issues that we're talking about here.
Okay. Thank you, Mr. McCarthy. Mr. Adams, so if you'll start by telling me the extent to which the amended notice that was filed on April the 30th addressed some of your concerns, and what concerns you still have.
Yes, Your Honor. And real quick, that amended notice on April the 30th was my amended notice for forming and shoring's 30B6. That's not what's in dispute. The dispute is the 30B6 of
the original
Stone
one
Mountain.
that was filed on the 3rd of April.
I am looking. I believe it's actually the 6th of April is what we're talking about. It's the Stone Mountain. It's the 30B6 notice to take Stone Mountain's deposition filed by Mr. McCarthy in forming and shoring.
Okay.
And there's only the one version of it.
Okay. Thank you for the clarification. Mr. Adams, please go ahead.
Yes, Your Honor. And so the issues here are, I mean, it's what's laid out in the motion, as a lot of these topics are very broad. We've already had some depositions in this case. I think we've taken almost 5 thus far, and the testimonies come out that there were millions of pieces, about almost a million pieces of equipment that went between these companies over 10 years. And the topics that I was given for examining Stone Mountain are for all materials that were ever rented by Stone Mountain from forming and shoring, and all rentals that were ever rented. And when we're looking at the amount of rentals here, we're looking, what's in dispute is a very small percentage of the business that was done between these companies. The Stone Mountain has been a customer of forming and shoring since forming and shoring opened its doors, continuously rented from them for about 10 years until things fell apart. And the topics are seeking to examine Stone Mountain on each and every piece of equipment that's ever gone between them, and each and every rental that's gone between them, and each and every contract that's gone between them, which the way that they did business was through separate contracts of terms and conditions on the backside of pickup tickets for each rental. There's no master contract here. And so there's already a good bit of information, a good bit of pieces of equipment in dispute in this case. And what I've been trying to do with Mr. McCarthy is have him narrow his topics to be reasonably particular to what's actually in dispute here. Where as worded currently, in particular topics 1 through 3, seek to examine Stone Mountain on, again, about 1 million pieces of equipment, and that's a testimony from Mr. Justin Revis, the owner of Forming and Shoring. And so that's the purpose of what's going on here, but in the motion. And I think that Mr. McCarthy and I have a different understanding of how this process should work. On my end, I know Mr. McCarthy just said that if we're not going to testify to something, we can stipulate to it. And it's my understanding that he has to issue a 30B6 notice that has topics that are reasonably particular for the examination of Stone Mountain. It's not our duty to make sure that to narrow his topics for him. It's his duty to make sure that his topics are reasonably particular so that I can actually prepare a witness or witnesses to testify on those topics. And so that's where we are currently. We can get more into the nitty gritty, but I will stop talking for a moment.
Okay, thank you, Mr. Adams. Mr. McCarthy?
Yes, Your Honor. Just for example, on topic number 1, we asked about the contracts, any contracts or business relationships between plaintiff and defendant. There's a course of dealing argument that's going to be made. I'm trying to find out, what are you guys going to testify to as to the course of dealing? If somebody says, I'm not going to be testifying to something starting from 5 years earlier, then I only need to know what it is in the last 5 years. That was my offered stipulation of how to handle that. If we want, all I'm looking for, Judge, is to find out that I don't hear for the first time at trial something that they're going to testify to that they say is an important matter, and we don't hear about it until trial. I mean, we got into an argument about what the definition is of items leased or rented from plaintiff. Well, the reason we didn't have a definition of scaffolding equipment is because I didn't want to get into an argument about whether a particular screw, nut, bolt, or whatever is not going to meet their definition or anyone's definition of scaffolding equipment. So that's why we're here. We're just trying to be reasonable. If his people are only going to say, hey, we only have information to testify as to the last 5 years, that was something I offered him as a stipulation. Judge, I've been doing this 35 years. I've never had anybody tell me that my 30B6 notice, when I'm asking about what you guys are going to testify about, is overly broad or not specific enough, because the whole idea of a 30B6 is to find out what they're coming into court with to talk about. Okay. So when I ask about the contracts or business relationships, if they're going to not talk about something that goes back beyond a certain period of time, then he can stipulate to that. That's fine. As to the materials that were leased or rented, some of the equipment that they have has gone back for years and years on the leasing. It's leased for a month. It's leased on a monthly, and it's a 28-day month in the business. But they've had some of the equipment for many years. So that's why I'm asking, what about all this equipment? Their big problem is the guy who ran their yard left the company. And they apparently can't get in contact with him because they're desperately trying to find out from us if we knew how to get in contact with him. But that's the guy who ran their yard. We want to know, another question we want to know is, what did they talk about, or are they going to talk about in terms of communications on what was leased or rented? If they're only going to talk about what was leased or rented that's in dispute, that's fine. But the dispute on the equipment goes back many years that it's been outstanding. They went all the way up until May of 23, Your Honor, paying on these invoices and then stopped. And the reason they stopped, that we found out so far, is because they didn't see the product in their yard, so they must not have it. That's where we're at with respect to their process of their affirmative defenses. They say they don't have to testify on affirmative defenses. It's their affirmative defenses. I'm sorry, that I'm entitled to know that. There's no court in the land that would say I'm not entitled to give them a notice and say, hey, I need you to testify on your answer on affirmative defenses. And that's not overly broad. They don't have that many. But that's where we're at, Your Honor. If you go through, it's pretty simple. We ask them, what steps they've taken to determine the location of the items leased or rented from the plaintiff. If they want to look for only the ones that are in dispute, they can stipulate to that. But we'd like to know what they did to look for it. Because I think what happened is you'll hear testimony, they have a horrible tracking system. And that's where their problem comes about.
Thank you, Mr. McCarthy. Couple of questions. Let me start with some of the ones that are a little more straightforward. Mr. Adams, as I understand your motion, your position is that requests 1, 2, 3, 4, 6, 7, 8, and 13 are overly broad. Is that correct?
More or less, I think
Or
it's
not reasonably particular is the better way to put it. I apologize.
yeah. I mean, they're all not reasonably particular. 1 through 3 are the ones in particularly that are overly broad that encompass what Form Insuring is specified to be 1 million pieces of equipment, which are probably thousands of rentals over the course of 10 years. 4, 6, and 7, really, that's more of an issue of defining the scope of the request. I mean, it's overly broad, but I think it's a quick fix on that, in which Mr. McCarthy just described them as items leased or rented, which again, we're not here to talk about all of the millions of items that, or sorry, the million items that were rented here. We're here to talk about what's actually in dispute, what they're claiming we should either pay rental for or pay a conversion fee for, or both, as they're claiming for many of them. And then the issue on 8, 13, and 15 is it's just asking for testimony generally on documents. Okay, well, what portions of the documents? What do you actually want to know about the documents? They're just asking generally to say, okay, well, testify about all the, I mean, for example, topic 15 is testify on all documents ever produced by defendant in this matter. And the efforts in searching, which the efforts in searching is not the issue. The issue is, okay, we need someone to testify on every single document that's been produced. But just broadly throwing that out there. Okay, well, what documents? We bait stamp them. You can identify them particularly. What do you want to know about the documents? Are these questions about authorship? Are these questions about how they were generated? Is it questions about the content? I have absolutely no idea and can't prepare a witness on that. So those are kind of the 3 areas to break them into, at least if that helps at all.
It does. Thank you, Mr. Adams. Okay, so let me start with the ones that seem to me to be relatively straightforward. So generally speaking, item 1, I don't think there's a basis for you to limit. I don't think that it lacks reasonable particularity. I mean, someone at Stone Mountain ought to be in a position to talk generally, at least, about the contracts and business relationship between the plaintiff and defendant, including the general terms of that relationship. Particularly because, as Mr. McCarthy points out, when you're talking about an ongoing business relationship, part of what may or may not end up being relevant is going to be a course of dealing. I agree with you, Mr. Adams, that item number 2, all materials ever leased, sounds really, really broad. And I don't necessarily believe that you need to have a witness prepared to granularly testify about every single piece of equipment. But the general proposition that someone over a 10-year relationship ought to be able to testify to the general categories and nature of the materials that are rented and the nature of that ongoing relationship, if there is in fact a course of dealing over the span of 10 years. And more importantly, other than Mr. McCarthy's offer to limit it to more recent time, because apparently the only equipment that's in dispute is of more recent origin, I'm not even sure how one would limit it, because you're right that they might be suing for payment over specific pieces of equipment that are subject to specific invoices. But if the manner in which that was handled is the subject of a course of dealing that might become relevant at trial, then it seems reasonable for them to inquire into it. And so I'm struggling generally if there's a way that it can be limited to make it still address the issues in the case. I'm willing to do that, and I think it's reasonable, particularly when it's written so broadly. But I'm actually struggling with how to make it more limited. Mr. Adams, on item number 2, do you have a suggestion other than Mr. McCarthy's proffered? Well, we could just limit it to the most recent 5 years.
Sure. And to be clear, I don't think Mr. McCarthy was offering to limit it to the 5 years. I think he's asking Stone Mountain to limit themselves to say that it's 5 years. And some of these rentals are going back to 2017. So we have about 8 years worth of rentals here. And again, that's part of the issue with this case in general. Is even if we limit it to everything that's relevant in the case here, we're talking about thousands of pieces of equipment. We're talking about tons of invoices, and we're talking about 8 years worth of time. So I'm also struggling a bit with it as well. I mean, if I think at the very least identifying it as the equipment that's in dispute here, either equipment that's been invoiced for with the invoices they've produced, or something that, I mean, they've produced a chart that's actually quite helpful, and that kind of lays out equipment rentals, and so we could even limit it to what the that chart as to what's in dispute, because that chart only includes what's in dispute to my knowledge and according to the testimony of the forming and shoring folks. So perhaps limiting it to that, even then, it's quite the burden on Stone Mountain to have to testify on as to all of those materials and all those equipment as well. And same goes for the communications, right? I mean, a communication can be one of our folks picking it up from forming and shoring's yard, having a verbal conversation while picking it up, and
All
maybe
right, Mr.
other folks.
Adams, forgive me for interrupting you. Just 1 second. Sorry, that was my deputy coming in to check on some stuff. So sorry for the interruption, Mr. Adams. Go ahead.
Nope, no worries at all. And what I was saying was I think the issue in topic 2 will spread to the same issue on topic 3 as well. In terms of it's asking for all the renting and leasing of forming and shoring's property. Again, communications can be just a verbal conversation that our person had picking up the equipment from forming and shoring's yard. I mean, maybe we limit that to written communications, or we limit it to communications that have been produced thus far. I'm not exactly sure how Mr. McCarthy is supposed to be or should be limiting them. And I mean, I tried to give some suggestions that I was met with pretty much nothing. And so I think at the very least, this needs to be limited to what's actually in dispute here, as opposed to everything that's ever been rented.
Okay.
Your Honor, I have a suggestion. Your Honor,
Yes, sir.
I've been doing this 35 years. Okay, I hate to keep saying that, but I have
Yep.
no interest in getting into something that's not going to be coming into the trial. But I just want to know, they've got somebody who's going to step up and say, oh no, in 2017, we talked about this and we did it this way. That's the kind of information we're trying to stave off on the 30B6, and that's why we have to have it somewhat broad. I'm not going to come back to Your Honor and ask you to hold him in contempt or for a motion to compel if the guy doesn't remember every specific conversation at a time. I'm just trying to find out what he testifies to. And then if he testifies differently at trial, I get to ask him, well, wait a minute, when I took your deposition, you didn't think it was important to say it then, but you think it's important now. That's what we're looking at, Your Honor. We don't want to get sandbagged.
Okay. Let's move on to item number 4. As I understand, very broad strokes, as I understand the complaint, the allegation is that forming and shoring provided equipment to Stone Mountain Access Systems, and they allege it was equipment rental to the tune of about $165,000 that was not paid by Stone Mountain Access. Now, in reviewing the answer that Stone Mountain filed, and we'll get into the affirmative defenses in a moment, but it appears that there's an allegation of set off There's an allegation of release and waiver, although I never really know if those are just I have to allege all these things so I don't waive them, and we'll figure it out. And those are always fair. That's fair, and I don't begrudge anyone doing that. I guess what I don't understand is my general understanding, if part of the issue is that there is a lack of keeping track of what was loaned and how long it was loaned and what was owed on it, then it seems pretty obvious to me that defendant's manner of keeping track of those things would be relevant potentially. It would be reasonably calculated to lead to the admissibility, to the, discovery of admissible evidence. And I also am not sure how that's overly broad. I mean, certainly it would seem like if or rather not reasonably particular, it would seem like it would have to be somebody at Stone Mountain's job to keep track, and therefore would be able to talk about what their process is for keeping track of equipment that it rents. I'm not sure I understand why your concern is that is it simply because of the volume of the equipment that's going back and forth?
Yeah, Your Honor. Yeah, there's no issue about. Of course, they should be asking about the tracking and the cataloging of equipment. That's fine. But again, the equipment that's in either the narrow to the equipment that's in play here, or just to or just to the scaffolding equipment that we're actually talking about. I mean, there are rentals of other equipment that Stone Mountain does, or other items. Sorry, this isn't even equipment. It just says items. So items is very generic, very broad. It can mean anything almost. I mean, that's being rented or leased by Stone Mountain. If we're actually talking about actual scaffolding equipment, which is what forming and shoring deals in, then that's fine. And I think that solves the issue for um, 6, 4, 6, and 7. A 7 in particular, or 6 and 7 in particular, would be forming and shoring's equipment. Perhaps I believe it's the equipment that they're charging for and that they have in dispute in this case. But yeah, and then 4 again, just the issue is on just the generic description of items that are being leased and rented. It's not on the actual information of tracking and cataloging scaffolding equipment. That's fine.
Okay. I mean, I would grant you that in item 4, as opposed to 6 and 7, it's talking about items leased or rented from any entity, as opposed to items leased or rented from plaintiff. But other than that, again, if we're talking about general business practices, that seems like something that a 30B6, that a corporate entity ought to be able to testify generally about its methods of tracking equipment that it leases and rents. And if it does it in one way for the plaintiff in this case, and a different way for other entities, that still seems like it would be reasonably calculated to lead to the discovery of admissible evidence here. What, other than the generic broad way in which it is stated, I'm not quite sure I understand the defendant's objection to being asked about its affirmative defenses. And other than the fact that, of course, we've all watched people get asked about their answer and affirmative defenses, and the real answer is, well, the lawyer drafted it. So
Right.
there's always that awkward, I don't really know what you're talking about because that's what my lawyer did. That's fair. But generally speaking, if there's substantive factual information included in the answer, particularly as to affirmative defenses like set off, potentially release and waiver, and I guess it looks like there's an allegation of conversion, or that those claims are duplicative. What is your concern about item number 8, other than as I mentioned, that the client's going to be like, the lawyer was in charge of that part?
Yeah, so as to 8, there's never been any issue of saying that they can't testify to the affirmative defenses. That's on the 6.4 communications. That was not discussed on the phone. I don't have any idea where that has come from here today. The issue with that topic is asking them to generally testify on the document. And again, 8 is not nearly as egregious as 15, asking general testimony on every document we've produced in this case. But again, 8 is just asking to testify generally on the document, on the answer. Okay, so what do you want to know about the document? Do you want to know who is involved in drafting it? Do you know who is involved, with the attorneys? Are there particular top paragraphs that you can narrow it down to, as Mr. McCarthy did in his response to my 6.4 letter, which is kind of exactly what I was getting at. He said on the fact he wanted to as to that answer, the person can be designated to answer questions on a factual basis for responses in paragraphs 2, 3, 4, 7, 26. Great. I mean, I think I think if it's limited to those paragraphs and it's rewritten as such, then that's perfectly fine. And of course, on the affirmative defenses, as long as they're not withdrawn beforehand, why not ask them about that? That was never an issue and never discussed. That's never been an
Well, Your
issue.
Honor, with all due respect to Mr. Adams, it's what he's asked for in his protective order. So that's part of the issue. He's now backtracking and saying, okay, well, I'll allow those. Why didn't we just have the deposition go forward on some of these at least? And instead we're getting stonewalled on things that are fairly obvious.
Okay. Well, and Mr. Adams, I don't know about whether you're backtracking or not, but to the extent that y'all have had good faith 6.4 communications to try and resolve these, and item number 8 has been resolved to your satisfaction, then you don't have to explain it to me. You can just say we've worked that out. It's no longer a part of the motion, or it's no longer something that I'm seeking relief on.
Well, so and Your Honor, really the issue then is, I mean, if he amends the topic, then great, then that's figured out. I don't want there to be I don't want there to be an amended notice to go out with the same overly broad topic that doesn't get amended as was pointed out in Mr. McCarthy's response to my 6.4 communication. And then my client's on the hook for having to testify generally as to everything. And then has kind of the rug pulled out from under them. That's the concern there.
Mr.
On that
Adams,
particular issue. Yes.
two questions I have. One is, and as we're moving into items 13 and 15, how large a concern is Stone Mountain? Give me an idea of the number of employees, the volume of work that it does, that sort of thing.
Yes. So Stone Mountain is I guess, maybe semi-national organization. They've got offices in they have office in Atlanta, then Florida. They have several in Florida. They have a main office out in Chicago, out in Illinois. They have the Atlanta office is fairly sizable. I don't know the exact number of employees, but they do a lot of business, and they have and it's quite a busy branch. And so it is not a small company by any means.
Okay. And then what is the volume of the discovery that we're talking about? When, I mean, as I understand it, it seems as if your objection really is to whoever the 30B6 witness or witnesses are, being asked generally about documents that have been produced. And so one question I have, or the subjects identified, one of the questions I have is what kind of volume are we talking about? Thousands of pages? Are we talking about hundreds of pages? Are we talking about tens of thousands of pages?
I believe we're talking about hundreds here. I can pull up to see what we've produced thus far. But I know, I mean, it is not, it's definitely not, I don't think it's thousands. It's definitely not tens of thousands on our end. I can try to look that up right now.
Okay. Well, I don't need a specific number. It was more just a general feel. And then is the back to my question about the size and scope of Stone Mountain, is this a situation in which the ongoing relationship with forming and shoring was limited primarily, like the people with knowledge that might be identified on these areas are going to be associated with the Atlanta office? I guess what I'm trying to figure out is this a Atlanta office was dealing with these people, and so we're talking about a universe of not thousands of employees, not hundreds of employees, but maybe 20 or 30 employees, of whom 3 or 4 or 5 might be the ones who would potentially have relevant knowledge.
That's probably more accurate. Yes. I mean, almost all of these rentals were done with the Atlanta office. There are a few with our Nashville office,
Okay.
which I forgot to mention earlier.
It's only $10,000 worth, right?
It's not much.
Ish.
Yeah, it's not much, and it's only a couple rentals on the Nashville side. So yes, to answer your question.
Okay. So the reason I was asking all those questions is Mr. Adams, as I said sort of at the beginning, I just don't see the concern that you are raising regarding items 1, 2, 3, and 4. At best, I think there's probably an argument that all materials ever leased or rented by the defendant is probably stated in a way that is overly broad or lacking in reasonable particularity. But under the circumstances, given that the potential course of dealing will be potentially relevant in this case, I don't know that it is an appropriate manner to limit this. Similarly, I don't, again, item number 4 says from any entity. And yes, that is a little bit broad when you look at it. But at the end of the day, what the plaintiff is actually asking about is what are the business practices of the company to determine, to obtain, catalog, track, and return items that are leased. And the same for stopping payment on items, which should be a relatively closed universe. But in terms of why they stopped payment and what efforts were undertaken to determine the location. So for those reasons, I don't believe that there's any reason to limit them other than any offer that has already been made by Mr. McCarthy. And I think that largely these matters can be resolved through an effort to conduct the deposition in terms of identifying appropriate 30B6 witness or witnesses. As to the answer, which is item 8, the interrogatories, which is item 13, and the request for production, which is item 15. Mr. Adams, I share your concerns that it is often quite awkward when we're asking our clients about the discovery, because that's largely a task that is completed by the attorney. Or when we're asking our client about what's stated in an answer or affirmative defenses. But the fact of the matter is that information had to have come from your client. And so someone at the company has to know of and be aware of how that information was communicated to the lawyer, such that it could be produced, why and how it was determined to be relevant and admissible and discoverable and producible. And obviously that gets very rapidly into areas of, discussions that you were having with your client and instructions that you were providing to your client or communications you have with your client. And certainly I don't understand Mr. McCarthy to be intending to inquire into areas like that. But at the end of the day, I don't think it's an improper question or that it lacks reasonable particularity to ask a party about their answer and their affirmative defenses, and to ask a party about their answers to discovery. And if it becomes abusive or overly burdensome in the context of the deposition, I am widely available and always happy to jump on Zoom and or a phone conference. And that is true even when I am not here in the office. The only real limitation on my ability to jump on a Zoom is if I'm actively in trial. And even then I can often take a break. And so it feels to me that the general basis for your motion, Mr. Adams, is going to be denied. I don't think that there is a basis, certainly not to protect defendant Stone Mountain from these areas of inquiry generally. And I don't know that there is a reason to limit the scope of them or to require Mr. McCarthy to provide an amended 30B6 notice that somehow limits these inquiries, because I don't think that they're unreasonably broad or lacking in particularity. Now, in the context of the deposition, if a matter comes up, the parties can contact me and we'll see if we can work through that issue. I mean, the other thing I will say is it sounds to me, because we were talking about a relatively closed universe, perhaps this former employee, Mr. Harris, or something like that. But it seems like there might be a few people that have knowledge of this ongoing relationship over the course of however many years. And that's not an unreasonable number of people, either to be deposed individually and or after y'all have conducted individual depositions, to be identified as representatives of the corporation to testify on behalf of the corporation. And so ultimately my short, that's a very long way of saying that my short answer is I'm denying your motion for protective order in its entirety, in the sense that I don't believe that there is a basis to either prohibit the deposition or limit the scope of the deposition or require forming and shoring to prepare an amended 30B6 notice. So that's going to be my ruling. Mr. McCarthy, can you send me a very brief, like 3-sentence proposed order that says that so that it will be in your file and you'll have a record of it?
Yes, Your Honor.
Okay. Do y'all need anything? And I don't, do y'all have these scheduled yet? Do you have the 30B6 set aside? Do you have days set aside?
Not at the
But
moment.
we had set it aside, so we'll need to schedule it, Your Honor. And then, Your Honor, we'll probably need to move back our scheduling order because we have dates that are due for the dispositive motions. I
Right, and
believe at the
that's,
end of the month.
yeah, thank you for pointing that out. I was going to mention that to y'all while I had you on the phone. So you guys are operating under a court issued scheduling order.
Yes, Your Honor.
And what my standing order, y'all can enter any dates that y'all think are reasonable. I mean, even though we're sort of past that point, maybe even discovery is closed, because when we issue a court issued scheduling order, we give y'all an insanely small amount of time to conduct discovery, and we do it on purpose. If y'all need more time, you're free to take it. You just need to submit a proposed amended scheduling order that gives y'all additional time. The only reason I asked about the deposition is those 2 reasons. Number one, I do think that y'all need an amended scheduling order if y'all anticipate that y'all are going to take additional time. And again, I don't, if y'all agree that it's going to take you some time to do those things, I don't have any objection to it as long as it's reasonable. Understanding that my preference is that you take as much time as you need rather than having to come back, oh, we're going to take 90 days and then come back. Oh, can we have some 90 more days?
Right.
Um, you know,
Always coming back. Yeah.
I know if you need 6 months, take 6 months. That's fine. I don't care. With the idea that you don't ask again, don't need to. The second thing, again, is the other reason I asked is to figure out when you're anticipating that 30B6 or those 30B6 witnesses might testify. And if y'all will just make sure that, maybe email Mr. Freehoff and say that it's been noticed for this day and that's when you intend to go forward. And that way it'll just be on my radar in case y'all need to reach out. So I'll know to try and be available at that time. Okay.
Yes,
Anything
Your Honor.
else you need from me, Mr. Adams?
No, Your Honor. Nothing else. Mr. McCarthy and I will get together on the amended scheduling order as well,
Okay,
and put that together for dates that can work for us and that we don't have to come back later and
right.
ask to be pushed again. So,
Yeah, and the main thing is just send that by in Word format to Mr. Freehoff by email, and he'll send it to me. And Mr. McCarthy, anything else you need from me?
Nothing further, Your Honor.
Okay, thank you all very much. Have a good day.
Thank you, Judge.
yes,